Hey everybody, welcome back to Guns and Gadgets. This is where you will find Second Amendment news, whether it's good, bad, ugly, or indifferent, every single day. And if you want to stay in the loop, hit that subscribe button down below. If you think the Second Amendment is paramount to our individual liberties, hit that subscribe button down below. Make sure you like the video so more people see it and share it. Now, yesterday when I was coming home from SHOT Show, I was in the skies and another big victory for the Second Amendment took place, and it had everything to do with the rushed through assault weapon ban in Illinois. Before I jump into that, I want to thank the sponsor of today's video, and that's Lear Capital. Last year was a terrible year for investors, and predictions are that 2023 will be even worse with the upcoming recession. But what did have a really impressive year this past year was gold investments. And 2023 is looking even better as some experts predict gold will be up 100% to $4,000 an ounce. I believe gold and silver are the safe haven assets to protect your savings and your retirement against inflation and recession. If you're interested in investing in gold, I suggest you call my friends at Lear Capital. The team at Lear will provide helpful information about purchasing gold or converting part of your IRA or your 401k into a gold IRA. There are a lot of gold companies out there to choose from. It can be confusing. I chose to do business with Lear Capital because not only are they the best around with over 25 years in business and thousands of 5-star reviews, but they also have a 24-hour risk-free guarantee where you can review your investment for 24 hours before committing to it. You can learn more at leargg.com or call 1-800-260-5075. Not only will Lear Capital give you your gold and silver investment guides, but you'll also get up to $15,000 in free bonus metals with the qualified purchase. So check them out again, leargg.com, 1-800-260-5075. Thanks to Lear Capital for sponsoring this video. All right, now let's get into this judge's decision and what he said, because Illinois just got kicked and I don't know if they're going to recover from it, and it's awesome. So on screen, this is the first page of yesterday's order. The temporary restraining order was issued by the judge in the 4th Judicial Circuit in Effingham County of Illinois. And it says, this matter having come in front of the court on an emergency motion for temporary restraining order by plaintiffs, the court having considered the pleadings of the parties, oral arguments of counsel, finds as follows. The matter before the court is one of significant importance. At issue is whether the defendants have fulfilled their obligation to enact legislation that furthers the legitimate issues of the public while following constitutionally required regulations. As the court addresses each element of the requested temporary restraining order, it is worth noting that defendants presented no evidence of legislative intent for the court to consider. Furthermore, an examination of the Illinois Legislative General Assembly history of the bill provided no further information. From January 28th of 22 to January 8th of 2023, HB 5471 was a change to the Illinois Insurance Code. Within 2 days, the bill was entirely gutted and replaced, as referred to in oral arguments by both parties, with an entirely different subject, and was immediately signed by Governor Pritzker. Except for the record of actions, the public record regarding this bill, including the hearings that were held, was almost entirely regarding the bill as an insurance regulation. The plaintiffs all appeared by counsel for the hearing, and the Attorney General Raoul and Governor Pritzker both appeared by counsel as well. Defendants Christopher Welch and Don Harmon failed to appear to the hearing. Attorneys for defendants Raoul and Pritzker argued the court should deny the request for temporary restraining order for the plaintiff's failure to meet the requirements of irreparable harm and likelihood of success on the merits. Now, this judge is saying, hey guys, this is an insurance bill that you stripped and ripped. You deleted all the text, took this gun control bill because you knew this bill was going to pass. You shoved this assault weapon ban in there and you rushed it through, and I caught you and I know it. And that's good, because this usually gets past a lot of legislative or just judicial tests, because the legislature, when they want something to pass, they'll rush it through. I've seen anti-gun bills put into amusement park bills because they know the amusement park bill is going to pass. Now, before I go further in this, I'm going to bring you to something that was actually said in the oral arguments that will put a lot of, it'll verify what we're saying, but for those who are on the fence, this might help you realize what we're fighting for. The court asks, You're suggesting that this legislation of keeping firearms out of the hands of the average citizen is a good thing? Mr. Kincaid, one of the attorneys, said 2 points. Well, 3 points. One is that's not the specific thing I'm referring to here. What I'm referring to here is not the provisions of the criminal code, which now makes it unlawful to possess or makes it unlawful to sell. In the future, will make it unlawful to possess certain types of weapons. That's not what this refers to. The judge says, you agree this act keeps firearms out of the hands of the average citizen except those otherwise enumerated? And the attorney says, yes. But wait, there's more. The attorneys also, in their babbling, said, there is no right belonging to an individual to participate in the legislative process. Really? There is no individual right to participate in the legislative process, due process, or otherwise. Of the people, for the people, by the people. That's us. We have a say in every step of the legislative process, you clown. And that's, guys and gals, that's why Illinois is like that. That's why Massachusetts is like that. That's why New York is like that. These people don't think you all matter anymore. They think that they are the kings and queens, and you guys and gals are peasants who just pay their salaries. And more, we're starting to see judges catch on to that and destroy, at least in our case, the Second Amendment, destroy gun control legislation and destroy the argument coming from the other side. Now back to this court decision that came out yesterday. The judge said, this argument could be considered moot, as the U.S. Supreme Court recently found in New York State Rifle and Pistol Association versus Bruin that the state of New York violated the Constitution when requiring proper cause in order to obtain a license to carry a gun. As requirements for possession of a weapon in the home is generally and necessarily less restrictive than carrying a weapon outside of the home, it follows that proper cause would be unallowable for possession as well. As training and experience are being used by the defendant to justify who can and cannot possess these weapons, it is an example of a use of proper cause and is therefore unconstitutional. Due to the lack of procedural compliance of the defendants, the court is left with nothing to conclude what might be the compelling public purpose of this legislation. In oral arguments, the defendants suggested that the goal of the legislation was to reduce firearms deaths and mass shooting casualties. However, they offered no evidence that the individuals in their newly created class, based on training and experience, were any more or less likely to commit these crimes, nor did they provide evidence that the individuals excluded from this class were more likely to commit crimes. The court finds that the plaintiffs have shown a likelihood of success in relation to the Equal Protection Clause of the Illinois State Constitution, and that the defendant's use of criteria, especially those that is not evenly applied, violates the face of the Supreme Court's findings in New York State Rifle and Pistol Association versus Bruin. So the judge is destroying what Illinois has done. The judge also found that these clowns rushing through, they violated the Due Process Clause of the state of Illinois. So they violated not only the U.S. Constitution, but also the Illinois State Constitution, guys and gals. And these are the judges that we've been waiting for. Judges now, thanks to the Supreme Court decision with the New York State Rifle and Pistol Association versus Bruin, the judges actually have a great a plan that they have to follow when a state is violating our Second Amendment rights. It is text, history, and tradition. It is not anything else. Feelings be damned. That's all they can go on because it happens to be a core enumerated right in the U.S. Bill of Rights, but we get that right from our Creator. We don't get it from government. And this judge is saying the same thing, guys and gals. This is great. To wrap it up, the judge said, it is hereby ordered, a temporary restraining order is entered enjoining the defendants or any administrative agency or law enforcement agency under its control from exercising any color of authority to enforce any and all elements of HB 5471. This order is binding upon all the parties in this action, including all of their officers, agents, employees, and attorneys. This matter is set for a preliminary injunction on February 1st of 2023 at 9:30 a.m. Signed, Judge Joshua Morrison. Now, this is a big win in Illinois because billionaire J.B. Pritzker wanted this no matter what, because this was going to be his stepping stone to run for president. Look what I did. Look what I did. I did something. Here's a quote from the governor following getting his butt kicked in court. He said, "This decision is not surprising. Although disappointing, it is the initial result we've seen in many cases brought by plaintiffs whose goal is to advance ideology over public safety. We are well aware that this is only the first step in defending this important legislation. I remain confident that the courts will uphold the constitutionality of Illinois' law, which aligns with the 8 other states with similar laws and was written in collaboration with lawmakers, advocates, and legal experts. Illinoisans have a right to feel safe in their front yards, at school, while eating at bars and restaurants or celebrating with their family and friends." Yeah, feel. The Constitution has nothing to do with feelings. The Protect Illinois Communities Act takes weapons of war and mass destruction off the street while allowing law-abiding gun owners to retain their collections. I look forward to the next steps in this case and receiving the decision this case merits. The Attorney General in Illinois said, "We disagree with the court's decision. We have filed a notice of appeal and will ask the appellate court to reverse and vacate the TRO." So this, like the judge said, it's up for preliminary injunction February 1st. So there's a few days in which they can go to the appellate court and get this overturned, a la what New York did. So if you want to stay up to date on what's going on, you want to keep this on your radar, then subscribe to Guns and Gadgets. I'll bring that news to you every single day. And I'm sure we'll hear something soon before the preliminary injunction hearing takes place. So there you go. Illinois blatantly disregarded the Constitution of Illinois and the U.S. Constitution, and they got smacked down. It is right now the enforcement of this assault weapon ban / magazine ban / rapid fire device ban / increase the use of red flag laws. It's on hold. And like I said, I'll let you know what happens with this appeal. Until we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. That's what it's for. It's our right. It is not Governor Pritzker's right. It is not Governor Hochul's right. It is not anybody else's right but ours. And you can't take it from us because it's not yours. You didn't give it to us. Guys and gals, I'll see you all in the next one. Take care.